For the record, I'm Delegate Michelle Guyton, and I'm here to ask for your favorable and thoughtful consideration of House Bill 450. It protects the privacy of sexual assault and stalking victims by redacting their names or shielding their information from easy access on public-facing documents and kiosks. Now, a couple of years ago, you may remember a similar bill that this body passed, and that was sponsored by your very own subcommittee chair, Delegate Phillips, and I appreciate that. The bill in front of you today is modeled very, very closely on his legislation that was passed previously, and you have heard this bill before. The only difference between what you're hearing today and what I presented to you last year is that we did add stalking victims to this legislation as well. Otherwise, it is exactly the same as what you heard last year with the amendments that we added during that hearing. And I don't need to express to this committee the stigma that is associated with sexual assault and the sensitive nature of reporting these sort of events. And we know, because of our experiences here and another testimony that you have, and also because of testimony that I provided you last year from an intern in my office, who told you that the reason that she brought this bill idea to me to begin with was because as a victim, she was afraid to go forward with charging and trying to report these crimes because she was so fearful of her identity being out there in public. You heard from her last year, and she did testify in the Senate this year, but as you know, these events can be re-traumatizing, and I just did not feel like her presence here today was necessary, but certainly she is on the record. So, when we first heard this, I actually went to your chair, Bartlett, and several other members and said, how can this be? I thought we protected the privacy of people who reported sexual assault. And I believe that we were all so excited about the bill that we had just passed that most people said, sure we do. Of course we do. In fact, we do not if they're over 18 years old. In fact, my staff and I went down to the courthouse in Towson, and we spent a very, very long and depressing day going down dark rabbit holes, looking up sexual assault cases based on information from the newspapers. And we found unshielded, unredacted information about victims in every single one of your jurisdictions, in every single county. So currently, this information is easily accessible. The legislation, I just want to point out, does not restrict any party to the case. Any party who needs information for this case, from that information, they have access to necessary information. It does, however, protect victims. It protects their identity, and it protects some terrible, horrible things that might happen to stalking victims if their information was publicly available. And I will tell you that what we found in those records were not just names. They were addresses. They were country of origin. They were requests for translators for different hearings, and all of this is completely unacceptable to be out there in the public eye. So I will ask for your favorable report on this bill, House Bill 450. I do want to point out it's been cross-filed by Senator Sarah Love. They had their hearing already earlier, I believe it was Wednesday or Thursday of last week. There is no opposition to this. It's a one-time fee to set up the original program for the bill to get this going. And I would like to just bring your attention to all the many letters of support that we have from our various caucuses in the House and Senate, and some fabulous organizations with whom we all work. So thank you very much for your hopefully favorable report.
Thank you. Good afternoon, Madam Chair, Madam Vice Chair, distinguished members of the committee. My name is Nicholas Steigerwald. I'm speaking on behalf of Turnaround, Inc. We are the Rape Crisis Center for Baltimore City and Baltimore County, and we are a comprehensive service provider for survivors of intimate partner violence, sexual violence, and human trafficking across the Baltimore County region, as well as Howard County. Far too often, survivors who bravely come forward to seek justice face the risk of having their most sensitive identifying information exposed. As Delegate Guyton expressed, this exposure can lead to further trauma, retaliation, and a chilling effect that discourages victims from reporting these crimes in the first place. Every day, survivors face an unimaginable reality, one where their safety is constantly at risk. When a survivor leaves that dangerous situation situation and engages with the criminal justice system, that danger only increases. Abusers often escalate behavior when a sense of loss is felt, and they will go to great lengths to maintain that control. Abusers will lash out emotionally and physically. Abusers will often engage in litigation abuse to use the very system designed to protect victims against them. These lawsuits are often thinly veiled attempts to intimidate the survivor into silence. Our legal advocates see this type of behavior all too often as they help survivors navigate the legal system. This bill addresses some of those dangers head on by providing a barrier to access for abusers to reach a survivor and intimidate them. By enacting this legislation, Maryland will take a strong stand and send a message that our justice system stands with survivors, prioritizing their privacy and safety. I urge you to support this legislation and make our courts a safer space for survivors of sexual assault and stalking to seek justice and rebuild their lives without the fear of exposure and re-traumatization. Thank you.
Thank you. Laura Wilt.
Right. Good afternoon. Thank you. My name is Laura Wilt, and I'm the senior attorney located in Baltimore City for Maryland Crime Victims Resource Center. We provide legal representation for victims throughout the state of Maryland. And on behalf of those victims, we are asking for a favorable report for House Bill 450. Victims of sexual assault, as you've heard, and stalking face significant fear connected with reporting these crimes, fear of retaliation, fear that everyone now is going to know the horror of what they have suffered. As you've heard, they often suffer and hesitate to report these crimes. And I would just point out that that hesitation, that lack of filing because of this creates opportunity for more victims and puts all of our family members and community in danger because it's emboldening those offenders. House Bill 450 is consistent with Article 47's mandate that victims of crime be treated with respect, with dignity, and sensitivity throughout the criminal justice process. I would like to conclude with a statement regarding this bill from Roberta Roper, our founder. She says, no victim of sexual assault should suffer the additional pain and trauma because their identities have been revealed. Every victim of sexual assault should have protection that they need and deserve as they journey through the criminal justice process. No victim of sexual assault should be blamed for the devastating trauma they endured. Yet we know all too often that society will question and will blame the victim and not the individual that chose to inflict this suffering. This is all too often a reaction from our public, I'm afraid. When the identity of a victim is not protected, their pain, their suffering, and their trauma are increased by our system. We ask, both Ms. Roper and I ask for a favorable report on House Bill 450. Thank you.
Thank you, members. This concludes the favorable panel. I'm sorry, this is our favorable panel. And I see one question. Are there any other questions? Delegate Simpson.
So for clarification, does this seal the entire record, which means it also protects the accused, or does it just redact? Are you just asking for the redaction of the victim?
Nowhere in this bill does it say that the record is sealed in any way. We're asking for the redaction of the information of the victim only.
Okay, thank you.
Delegate Phillips.
Thank you, Delegate. Thank you, Madam Chair, and thank you, Delegate Guyton. There were some favorable with amendments. I noticed the health-related boards had asked about that. Is there, does this bill still provide rational reasons for access to data should it be necessary?
Absolutely. Thank you so much for asking that question. This wasn't something that we heard from them last year or over the interim, actually, only just this past week. And we did meet with the health boards. I've also met with our colleagues over in the health committee and had conversations about this as well. They can get that information now. They would like to get it more easily and have it just handed over. But if they show a judge that they need this information, they absolutely do have have access for it. They also pointed out to us that it's only in about 7 cases a year combined that they need this. And so it's not an onerous thing for them to have to go through the process that is already in place for them to have the information necessary to investigate against a practitioner, whether it's an acupuncturist or a massage therapist. We don't believe it is necessary at all for them to have access to all of the pertinent information about the victim in order to have justice when it comes to recertification or licensure.
And I'd like you to reiterate, I think Delegate Simpson asked a good question because there was also a letter from the State's Attorneys Association that suggested, and it's interesting because I never heard that 2 years ago.
Yes, sir.
So would you reiterate that point?
Absolutely. Anyone who needs information can go to a judge, even under these bills that hopefully will be passed and have been passed, and show that there is necessity for that information. It is not shielded from everyone who is a party to the case and needs it. It is, however, going to be invisible for easy access to the public. That is what this bill does. That is what the bill we passed a few years ago does. And just to reference the favorable with amendments today, you noticed they were initially on the panel. I did not see those amendments until earlier today. They weren't amendments that we had discussed, nor were they discussed in great detail in the Senate hearing last week. And so that's why we had a little confusion up here at the beginning of the hearing. I do not personally believe that those amendments are necessary because we are not asking for shielding. We are asking for redaction of personal information from public-facing documents.
Thank you for bringing the bill.
Thank you so much.
Delegate Cardin?
Chair, thank you for reading the bill and your compelling testimony, Delegate Guyton. This policy is already in place for minors, isn't that correct?
That's accurate, yes.
Okay, so this is essentially be putting victims of sexual assault in the same place as minors are now.
In the same place, I'm sorry, giving them the same protection from revealing their identity, yes.
Okay, and it says that it's on notice. So do you have to proactively do something, or is it automatically redacted as soon as the filing happens?
It would be automatically redacted the same way. This bill, if you look at it carefully, which I'm sure you do, because you're an attorney and you do that, is written exactly in the same format, except for the addition of stalking victims as the original bill that we passed. And that is an automatic on notice at the time of charging.
And why are we including stalking?
Because advocates of stalking requested to be a part of the bill, and all of the advocates associated with it, including myself and Senator Love, felt that was a very reasonable protection.
Okay, so if a defendant is pro se, doesn't have an attorney to know how to request from a judge to get the information to provide a defense, how are they going to do it?
I'm not an attorney, as you are, and as many people on this committee are. I am certain that there are ways that they are doing it now when they are charged with abuse toward a minor, and I'm sure that whatever that process is would be the same in this case. I do know that it seems to be working well enough that we don't have any opposition from the judges or others this year, or the clerk of courts, which I have spoken to.
I would wonder if the defense, so not the public defender, but the Defense Association, Criminal Defense Association has taken a look at it. I'm just curious to know whether they have an opinion. But
yeah, this bill's been before you for 2 years, and I have not heard any opposition from them. So thank you. So I assume they're fine with it.
Thanks.
Delegate Phillips, did you have another question? Hold on, let me get the vice chair first, and then I'll come back to you.
Thank you, Madam Chair. Often we have cases where we don't rightly know who the victim is. We have opposing cases. He comes in and says she's been stalking me, and she comes in and says he's been stalking me, and it bothers me a little bit that this redaction is going to happen at the initial charge, because at that point they're both getting redacted. Could you address that?
I really can't. I mean, I thank you for the question. It's not a scenario that anyone's brought before me or that I've heard of before. I do believe you that it could happen. I think that It's important, and I understand if stalking does not fall under this bill, if you all choose to remove it, that's fine. I do think it's very, very important for people who have charges of sexual assault for their identity. I also believe stalking victims as well, for their identity to be protected. Otherwise, they are much, much less likely to come forward and make these allegations and keep these folks off the street. And it's important that that happen at the beginning so that they don't get, dragged through the mud during the process.
Okay. Delegate Phillips, and then Boucher.
So, Delegate, I want to make sure we're really clear on what this bill does. So a person's identity would be redacted, but all of the parties, and so if there was a defendant, all of the parties would be aware of the specific persons in victims in the matter, correct?
Certainly. You have the right to that information.
Right. And so if one case had one person and they were saying that the similar scenario, then both parties, because they were then parties of the case, would have that information, correct?
Yes,
Okay. Thank you.
and that's in the bill.
Delegate Boucher.
Thank you, Madam Chair. Thank you for bringing this bill, Delegate. It's my understanding that homosexual males are very resistant about bringing forth charges. Was there LGBTQ commuter caucus in the House solicited for support on this?
There was. Thank you for bringing that up. Actually, there was. This year, they haven't voted yet. We did get their support last year for this bill. I also have the Legislative Latino Caucus, the Women's Caucus, IMLA, most of the other big groups that you usually hear from.
Well,
thank you for that.
Thank you for being very much perceptive and aware of that issue and checking on it. Thank you.
Of course.
Seeing no further questions, that concludes Delegate Embry.
Thank you. I'm sorry. Thank you, Madam Chair. And Delegate, thank you. And obviously, I'm a co-sponsor and excited about the bill. In reading it in preparation for today, I realized that in paragraph 3 that talks about the redaction, it requires redaction of all identifying information. It's not specific to the victim. I just want to make sure that's your intent. So it would be any witness, even defendant's information. I'm not criticizing for that.
No, and you're welcome to criticize. The intent of the bill, the legislative intent of the bill, for the record, is to, and I'm looking to read this.
Yes, the paragraph 3 last.
Identifying information of the victim of sexual assault or a victim of stalking. That those records, that information would be redacted.
Okay, so so all identifying
not sure I'm
information, you're
seeing
hoping
it.
that the definition would limit it, not.
And I'm sorry, I'm not seeing exactly the
page-
line you're reading from.
Page 2, line 32.
32?
Yeah. Because it could be read by the person doing
Except to the victim or the
redacting,
victims
but it
unless the
covers
court of
entire
praise.
file regardless.
I believe that's just referring to the previous statement, but as an attorney, I am not an attorney. So as an attorney, if there is a problem with that language, then certainly I'm, open to
But your intent is just the
amendments in
victim.
that. But the intent is this applies only to the victims of sexual assault or the victims of stalking.
Thank you.
Quick question. So more on what where the vice chair was going. So in some cases, there may be dual, the victim is both parties in the sense of they have separate charges. One is saying it was this person, the other saying it was that person, okay? In that circumstance, if anyone is a victim, their information could be redacted. Is that a true statement? And maybe this is for Laura Wilt, maybe, unless you wanted to answer.
I'm sorry, this is for whom?
Laura Wilt, who is,
okay, yes.
she's an attorney, so that's why I was asking.
Thank you for that question, and I think I heard all of it. I think one important theme through all the questions is, like, if there are cross charges no matter what, if they're a party, if they're an accused, they're seeing everything. Nothing, if you're accused, you're seeing everything. It's not redacted for you in any way.
No, I
So
guess
does
what I'm
that get at the
asking,
heart of your question?
not quite. What I'm asking is, are both victims' information redacted when there are cross charges? In the
I think-
sense of the public being.
I don't see why it would be, because each document is very individual. One's one case number, so the victim is completely redacted from that, and it's a completely separate document that charges the cross charges.
Right, and that,
Two different
that individual in the cross charge would also be redacted as the victim.
Yes, in the opposing file.
Yes, right. Okay, I just wanted to make sure I was clear on that. Okay,
That's how I read it.
okay. Delegate Guyton, did you want to, you're fine?
I think that is over my head in legalese, to be honest. But I
Okay.
respect the goal. Again, the intent is any person who has been a victim of these crimes, their information should not be available to the public, only to the court.
Got it. Okay.
Thank you.
Members, seeing no further questions, that concludes the favorable testimony on House Bill 450. Now I'm going to call up favorable with amendment, Lisa Jordan, Debbie Feinstein.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We are here in very strong support of House Bill 450. And it is true that some concerns have arisen, but I really do not want anyone on this committee to think anything other than MCASA fully supports privacy for survivors, and we fully support this bill, and any suggestion that we are muddying the waters or anything like that is simply not correct. You've heard the reasons for this bill, so let me just address the concerns that have arisen, and one of them, Delegate Phillips, is new since your bill was heard and passed, and there is a concern that under the language of the bill, it may provide a little bit too much discretion to allow denying access to the entire file. That the language, unless the court or party disclosing or allowing inspection of the filing or record redacts all identifying information. I think there's a concern that maybe it should be until, and then that they should have a time limit when they have to redact. The situation in Washington, D.C. now with the Epstein Transparency Act is part of what is heightening the sensitivity of MCASA to this concern that government not use privacy to kind of deny access. We don't want privacy to deny accountability. So that's why we did express some concerns about the court's discretion here and want to say we have to redact. We cannot deny access altogether. The other issue, as you raised, is from the health boards, and I think this is a legitimate concern. And we'll share that when I've worked with clients, they tend to believe the health boards know. They think Ms. Feinstein or someone has told the Board of Physicians, which is 7, but there's also the Board of Acupuncture, the Board of Massage Therapists. There are many different boards, and there must be a way to do this. So we hold people accountable, we protect privacy, and we address all of these concerns together. So we certainly defer to the committee, but those are the concerns that have been raised, and we absolutely support House Bill 450.
Good afternoon, Madam Chair, Madam Vice Chair, Debbie Feinstein with the Montgomery County State's Attorney's Office. I also stand in strong support of this bill. To directly go to that last point, we are required to report to certain boards when someone has been convicted. That's a requirement. There's a database, and we do follow through with that legal requirement. I also want to speak to the stalking piece. Stalking is an incredibly lethal pathway, and we see in terms of the nexus between homicides and stalking, there's a direct nexus between someone having been stalked and then someone being later killed. I chair our domestic violence fatality review team, and sadly we see this nexus. So we've actually made some changes in my jurisdiction, and you'll hear me back here on another bill relating to stalking that emphasizes that concern. Currently in Montgomery County, I can tell you that we recognize the need for this because actually one of our detective sergeants is in the room today to testify in a different bill, but we don't include identifying information of victims in our charging documents related to sexual assault when they're charged by the police. We already say victim A, or we include initials for the very reasons that are, that have been articulated so far today. It's incredibly important, particularly in cases where it's a stranger sex assault and the parties aren't known to each other, to then put their information out there is scary and could be incredibly dangerous. So the need for this bill for both sexual assault victims and stalking victims is absolutely 100% vital. I also want to just confirm, based on our practice as prosecutors, that when we provide discovery to the defense attorneys or directly to the defendant, if they're unrepresented, they do receive information. We are allowed to not provide addresses of victims and witnesses in criminal cases, but we have to be able to articulate reasons for that, to not provide it to the opposing party, and then the court has to make a ruling on that. So there is transparency to the opposing side. Sometimes what we'll do is file a protective order to then prevent them from sharing that information with anyone else, because we don't want them then going to the media or going to someone and saying this person who lives at 123 Main Street, is the one that's accusing me and they're a liar. So we obviously don't want that to happen, so we'll ask for a protective order. I'm happy to answer any additional questions, but I do urge this committee to issue a favorable report and do stand in strong support of this bill.
Members, do we have any questions? Seeing none, thank you.